Hello बच्चों, let's see passage 2. Passage 2 talks about section 85 and 86 of IPC 1860 have codified the law related to intoxication. Intoxication का मतलब होता है not being in your state due to the consumption of toxic substances. Section 65 of IPC provides a complete defense to the person who committed an offense in the state of intoxication. तो यहाँ पे कंप्लीट डिफेंस है, अगर आप इंटॉक्सिकेटेड स्टेट में कोई भी ऑफेंस कमिट करते हैं तो उस चीज का, इफ ही एट द टाइम ऑफ डूइंग it was by reason of intoxication unable to understand the nature of act, or his act was contrary to law, provided that intoxicating substance was administered to him without his knowledge or against his will. तो ऐसा नहीं है कि आप इंटॉक्सिकेट खुद की मर्जी से हो रहे हैं, फिर आप जाके कोई एक्ट कर दे रहे हो और आप क्लेम कर रहे हैं कि ओ सॉरी मेरे को तो पता नहीं था, मैं अपने सेंसेस में नहीं था. This defense is only applicable when the intoxicating substance is given to you without your knowledge or against your will. तभी इस section 85 का applicability होगा. Whereas section 86 of the IPC deals with the case of voluntarily drunkenness and provides that in the case of voluntary drunkenness, knowledge will be imputed to the accused in the same manner as if no drunkenness. मतलब अगर आप अपनी मर्जी से विथ योर नॉलेज अगर आप ड्रंक हो रहे हैं तो इस केस में ऐसा ही माना जाएगा कि आप ड्रंक नहीं है. The point to be noted is that only knowledge is imputed and not necessarily the intention. यहाँ पे अगर आप कोई भी ऑफेंस कमिट करते हैं वॉलेंट्री ड्रंकनेस के बाद, तो यहाँ पे माना जाएगा कि आपको उस एक्ट की नॉलेज थी, आपका इंटेंशन था कि नहीं, वो चेक किया जाएगा. इन अदर वर्ड, सेक्शन इम्प्यूट्स दैट ड्रंकन मैन with the same knowledge as of the sober man if the facts and circumstances of the case do not rise to the same intention. The imputation of the knowledge is a legal fiction and constructive intention cannot be raised. Although the first part of the section talks about both intention as well as knowledge, but the later part only talks about the knowledge. If the parliament wants the imputation of intention as well, it would have been omitted the term from the later part of the section. तो ये बेसिकली बोल रहा है कि जो फर्स्ट पार्ट है वो बोलता है, वो दोनों चीज को इंक्लूड करता है, नॉलेज और इंटेंशन को, बट जो सेकंड पार्ट है कि अजम्पशन होएगा कि नॉलेज होगा बट इंटेंशन का अजम्पशन नहीं है, ये वहां पे नहीं लिखा गया कि इंटेंशन वर्ड को ओमिट किया गया है. तो बेसिकली पार्लियामेंट ने ओमिट किया तो हम यही कंसिडर करेंगे कि वो नहीं चाहता था कि वहां पे इंटेंशन को अज्यूम किया जाए. सो लेट्स सी द क्वेश्चंस. Question number 6 says XYZ have a party in bar where X persuaded Y and X to take alcoholic drink. Y and Z eventually succumbed to the persuasion or also consumed alcohol along with X. Y and Z has never consumed alcohol before. After intoxication, they had some argument between Y and Z pushed Y with full force, causing serious injury to Y. तो अब यहाँ पे Y को इंजरी हुई है Z की वजह से और ये दोनों ही इंटॉक्सिकेटेड स्टेट में थे. तो अब हमें बताना है कि Z की लाइबिलिटी क्या होगी इस केस में. सो लेट्स सी द ऑप्शन. Option number A talks about Z is liable. So Z will be liable in the present case because he consumed alcohol with his own with his own consent and he consumed it voluntarily, so Z will be liable. B says Z is not liable because he was intoxicated. This defense is only applicable when he was intoxicated without his knowledge. Here there was presence of knowledge and hence this is a wrong option. C says X is liable as X has persuaded them to consume alcohol while they had never consumed alcohol. यहाँ पे persuasion की बात नहीं है, यहाँ पे knowledge की बात की जाती है और क्योंकि यहाँ पे knowledge था on the part of Z and Y both, तो ये involuntary intoxication नहीं माना जाएगा. So this is also a wrong option. D says the writ of prohibition would be issued when the case was still pending and the court lacked jurisdiction, but the writ of certiorari would be issued in the cases where the decision had already been made. This is a totally out of context option. There is no such mention of writs in the question or in the passage, so this is also a wrong option. Question number 7 says says Dipesh is a big trader in stock market. One day he had profit of 10 crore in the share market. He decides to throw a big cocktail party. During the party he drank 10 glasses of alcohol and was completely incapable of knowing about his acts. Under this state of mind he raped Sanjana, his wife's best friend's daughter, and choked her to death. He pleads intoxication. तो यहाँ पे ऑलरेडी बोला गया कि he drank 10 glasses of alcohol and was completely incapable of knowing about his acts. Although he was incapable of knowing his act, but he drank 10 glasses of alcohol with his own knowledge. So although not having the knowledge of the act, he will be treated as he had the knowledge of the act. So let's decide the options on the basis of this. So option number A says the patient is not liable since he is incapable of knowing the nature of his act. This is a wrong option because the law presumes that when you have voluntarily intoxicated yourself, there is a presumption that you have the knowledge of the act you are doing it, and the knowledge of an voluntary intoxicated man is treated as same of the sober man. So this is a wrong option. B says the patient is not liable and will be granted protection under 85 of the Indian Penal Code. This is again a wrong option. There would be no defense under section 85 of the Indian Penal Code. Both A and B again a wrong option because both are wrong option. D says the patient is liable. This is right option because the patient did had the knowledge of the act, and knowledge of the act is necessary for, and voluntary drunkenness was involved. Let's see the eighth question. Mr. Gaurav went to a birthday party. One of his friends, Sham, wanted him to drink and requested Gaurav to drink one glass of wine with him. Gaurav, however, refused. Upset with this, Sham decided to mix a drop of wine in the glass of cold drink and served it to the Gaurav, who drank it. Gaurav suspected a minor difference in the taste of the cold drink, but nevertheless finished the glass of cold drink. He became drunk and slapped Pranjal Devi, one of the guests at the party, decide. So यहाँ पे basically उसने although उसने suspect किया कि शायद taste में कोई difference है, but still he finished the whole glass of cold drink, and after that he committed this act. Now we have to decide accordingly. Let's see the options. Option number A says Mr. Gaurav was held liable since he was capable of understanding the nature of his acts. Here he was not capable of understanding the nature of his act because he was involuntarily intoxicated. Although when he said no, his cold drink was mixed with a wine by his friend Shyam, and Gaurav did not have any knowledge of such mixing of intoxicated substance in his cold drink. So this is a wrong option. B says Mr. Gaurav cannot be held liable since he shall be protected under 85 section of IPC. 85 says that when you are involuntarily intoxicated, you will be treated, your actions will be treated as you didn't have the knowledge of same. So this is a right option. C says Mr. Gaurav can be held liable since he got drunk voluntarily. He did not get drunk voluntarily. He was involuntarily drunk and did not have the knowledge of same. So this is also a wrong option. D says Mr. Gaurav can be held liable since he had the knowledge of the wine being present in the drink and still drank it. He did not have the knowledge of wine being present. He just suspected it, and the amount was so low, the taste difference was so minor that there was no such per se approach which could be applied for detecting the presence of wine in the cold drink. So this is again a wrong option. Let's see question number 9. It says Jami was driving alone on the Meerut expressway. She encountered some robbers who forced her to surrender all her money and valuable items to them. The robbers further joined Jami to consume the entire bottle of alcohol that she had with her. After becoming drunk, Jami was left in the forest by the robbers. In this state of intoxication, Jami threw many stones at a 10-year-old child who was severely injured. Jami pleads intoxication, decide. Let's see the options. Option number A says Jami can be held liable since she had the knowledge of being intoxicated. Jami was intoxicated by force and coercion, as it is already been mentioned in the passage that Jami was forced to consume the entire bottle of alcohol. So this is a wrong option. B says Jami shall be held liable under section 86 of IPC. Again a wrong option because Jami did not have the knowledge of intoxication, and he or she did not consume it voluntarily. Hence, the defense of involuntary intoxication will be given. C says Jami shall not be held liable since she was involuntarily intoxicated. This is a right option. D says both A and B are correct, which is a wrong option. Let's see last question. Which of the following statement is true? We need to find out कि इन दोनों में से कौन सा statement true है. Let's see the statement A. If Anuj's friends insist he drinks alcohol and he left with no option to consume the same and thereafter hits a truck driver, he shall be protected under section 85 of the Indian Penal Code. Here Anuj, although was being insisted by his friend, he did had the knowledge of drinking because he drinks the alcohol by himself, so he will not be given any protection under section 85. So this is a wrong statement. B says if a landlord orders his tenant to leave the house on the ground that he has not paid the rent and the tenant thereafter goes to the bar, gets drunk and beats the landlord, he shall be protected under section 85 of the IPC. Here also the tenant himself went to the bar and got drunk. This means that he had voluntarily taken the toxic substances, and hence no defense under section 85 will be applicable to such tenant. So this is also a wrong statement. So let's see what is the final right option. A says only A is correct. This is wrong because A is not correct. B says only B is correct. Again, it is wrong. C says both A and B are correct. Again, a wrong option. D says none of the above. This is a right option because A and B both are wrong options. So, I hope the passage was understandable. Keep studying and all the best.